clients often ask, after there's been a custody order in place for a number of years, whether they can modify the custody. They're unhappy, times change, they want to see more of the child or whatever it is. And so the question is, can you get a modification? And the simple answer is, you can always file for a modification. You can do it anytime. You can do it a month, 2 months after the custody order went into place, or 2 or 3 years later, or 15 years later. There is no requirement to show a change of circumstances, which would be what is required with respect to support. In custody, it's always what is in the best interest of the child. So, Michael, if you have a client that comes in and wants to file for a modification, where do you file?
And that's a very technical question, and that's governed by our statutes. And the place to file is where the court entered the order, if the child or the parent still resides in that county or state. But if everybody left that county or state, you can file where the child has been residing for 6 months, immediately preceding when you seek to modify. It's called the home state of the child. Also, if a parent resides in the state where the order was entered, and the child has now been residing outside of that state or county for a long time, and all the evidence and everything about the child is now outside of that issuing state, you can go back to that issuing state and ask to move the case to where the child now has been residing. But the thing to remember is, if someone still lives in that issuing state, you have to first go back there to ask to move it.